Morning, Judge.
Hey,
How much are you? Right around.
yeah, I want to go back to bed. Good morning, Mr. Salas. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail.
Hold up DWI and evading arrest. This defendant's morning just turned into a legal nightmare. But watch closely, because what the judge doesn't say here may be just as important as what he does.
And/or a $2,000 fine. You're also charged with evading arrest or detention. On that, you're facing up to a year in jail and/or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have a cannot afford one to be appointed to. So. Okay.
On or about March 26, 2025, an officer was on patrol on Gulf Freeway in Harris County, Texas. The officer observed a motor vehicle disabled in the left hand, grass median, dividing southbound and northbound lanes of traffic. The motor vehicle had multiple airbags deployed and all four tires appeared to be damaged. On arrival, the officer observed additional motor vehicle disabled on the open access roadway of what was formerly a car dealership. The officer observed the witness walking towards the officer, trying to get the officer's attention. The witness said that 5 minutes prior to the officer's arrival, the defendant approached the witness.
For busted tires, airbags deployed, multiple cars disabled, this isn't your average fender bender. Sounds more like a demolition derby with a side of felony charges. But will they actually prove he was the one behind the wheel?
After the witness' tire was blown out, the witness informed the officer that the defendant demanded to use the witness's phone. The witness advised the officer that the defendant wanted to contact the defendant's mother to pick up the defendant from the scene. The witness told the officer that the defendant continued to approach aggressively, and that the witness told the defendant the witness would call the police if the defendant did not stop. The witness said the defendant fled the scene on foot. The witness described the defendant's clothing, and the officer observed the individual matching the description running and approaching the scene of the incident. As the defendant approached the scene of the accident, the defendant began walking in a parking lot adjacent to the freeway. The officer gave loud verbal commands for the defendant to stop. The defendant fled on foot on the grass along a ditch at Water Creek, then climbed the fence attached to private residence, and fled on foot for approximately 0.4 miles before he was then detained by a police department, turned over to deputy. The scene was moved to a Shell station to continue the investigation. The officers contacted the defendant. The officers observed a strong odor of alcoholic beverage emitting from the defendant, and the officers observed the defendant have red glossy eyes, slurred speech, dry mouth, repeating phrases, and agitated demeanor.
You say a shaky demeanor?
Sorry, agitated demeanor. And the defendant denied drinking alcohol, and initially denied drug use, and then stated that he had been off for a couple of days and had consumed paste or coke. The officer, through training experience, noticed to be representing cocaine. The defendant admitted that he was going to a girl's house when the incident occurred, and agreed to perform the standardized field sobriety tests. Those were administered, and the officer observed success exclusion on the HGN. The officer did not administer the walking tour of the one-leg stand due to the defendant injuring his feet while fleeing. The defendant considered to a breast sample, which was not completed due to interference being detected. The officer obtained a search warrant for the defendant's blood, and there was a blood draw for the defendant.
Okay. Your Honor, may I come?
Please.
I might have missed something, but besides the state saying that my client said he was going to someone's house, I didn't hear any operation facts.
I mean, he admits driving. He's by the car when the officers get there, right? Is he by the car when the officers get there, or where is he?
From what I have, Your Honor, he has fled the scene when the officers get there, and then comes back to the scene.
Okay.
To the officers. The witness.
Does the witness put him operating at all?
This is where it gets tricky. The defense is pressing hard no one actually saw him driving. And in a DWI case, that's a serious weak spot. What would you do if you were the judge here? Comment below.
Yeah, just one moment, Your Honor.
Yeah, all I heard is going somewhere. It doesn't say he was driving. So if you see how the DWI, they might refollow, but part of it, they don't corner. Sometimes they fade in, it's getting going.
I'm not sure, Your Honor, there was anything additional. No. This is kind of up in this mirror.
Hey, good to
See you again, Your Honor.
What's up, man? Good to see you. Do you have anything else?
Your Honor, it does look like the witness stated that he stopped and exited his vehicle and observed the driver of the RAV4. That's what I have, but
So it doesn't match up with my point.
Martinez stated once he stopped and exited the vehicle, he observed the driver of the RAV4, identified as Abraham Elias Salas, using driver's license, come out from the grass near the RAV4 and aggressively approach him, requesting to use his cell phone. Stated that he was trying to use his cell phone to call his mother to come pick him up, and that Salas said the RAV4 belonged to his mother. Martinez stated after a short time that Salas asked Martinez if he had papers for immigration.
Judge, even with these facts, it doesn't show driving. Even if he owned the car, we have no idea when. There's no facts to say that he was driving the car, that he admitted to driving the car. I don't see operation.
So Salas stated that he was driving the RAV4 because he was going to a female's house and continued to speak. Salas then stated that he ended up in the grass because he was scared. Then stated that he was a Mexican driver that swerved in front of him. And
He said a Mexican driver swerved in front of him. Is that what he said?
told him no Tango Papelas or I don't have paper. Salas said the other driver was in a gray Toyota, telling him to go away. Stated that the RAV4 and the alleged Toyota came into contact, causing a collision. Salas stated that he was coming from his house in Friendswood, but denied having anything to drink.
I think if they
he was operating the vehicle at the time of the accident.
and you have the other person say something, right?
they say that it was. They identified him as the driver.
They just never say they saw him driving the vehicle.
So I believe that they believe, based off the circumstances, that he was a driver. I don't know if we just actually saw him driving. What we have to prove the driving facts is that Reeves fired to believe prior to his arrest. He admits that he was driving the vehicle at the time of the accident, and the vehicle was found at the scene of an accident. He was found nearby.
There it is, an admission. But here's the legal twist. An admission alone doesn't seal the deal. You still need evidence to connect that person to the act of driving at the time of the incident. This is where reasonable doubt creeps in.
Was observed coming out of the grass nearby. By the property.
Although it's an admission, Judge, it needs to be an admission plus. I don't see that being enough for the plus.
Mr. Salas, I'm going to find that there's no probable cause in your case. Every freaking day in our county, someone dies from an alcohol-related collision. Don't become a statistic because of a boneheaded move that you make where you kill someone. Do you understand? Now, I'm going to find no probable cause. It's very possible they go indict this case at a later time if they get more evidence. But don't kill anyone. Do you understand?
Yes, John.
See,
Thank you. Are there any conditions you're imposing on the evading case?
no, I'm going to find no.
Oh, thank you, Judge.
Talk to me.
Desmond Smith. He's one of the ones that,
Yeah, once. Okay. What's the last name?
Smith, Desnick, did you do? Out of Louisiana, one of those four guys that you already talked about. He's the one that did not have he was a passenger, not the one with the weapon.
There were 3 passengers.
I talked to his mother.
How old is this kid?
He's awfully young. I can't use the computer, I don't. He looks awfully young. I talked to his mother. His mother's willing to post bond and able to post bond if it's reasonable.
Therein lies the question. What is reasonable? Right.
1,500 would be reasonable.
And boom, no probable cause. That's a massive moment. But before you celebrate, remember, prosecutors can still bring this case back with a grand jury indictment. This isn't over, it's just on pause.
I know. Nelson, did they respond?
What's that?
Did they respond on Nelson?
Smith. Then bring up Mr. Smith.
Okay, yeah, we're on Smith.
Smith's coming out now.
Black claims that they told them they were not going to mess with it. But we'll still wait for the official word from Florida. What's that name of that city?
I don't know that. I just went by the county.
It's another one of those.
I've been mispronouncing.
Natchitoches.
I've been mispronouncing
I
county.
know.
Morning, Mr. Smith. How's jail?
Worst experience of my life, bro.
Makes me really happy. It's supposed to be, you know? The idea of jails are that you learn. And unfortunately, we have people that just don't get it. No matter how long the sentences are, no matter how cold the bars get, they just don't get it. You're wanted out of Louisiana for this car.
So,
Your lawyer's asking for me to set you a bond, but I don't know. I've never met you before. I don't know you. You know, one of the things that I consider is, number one, are you going to go back if we set you a bond? Number two, are you a dangerous person? Because I don't want to set you a bond and then you leave a wake of destruction on your way to Louisiana. I mean, I don't want that.
so
So, Mr. Kim, tell me about Mr. Smith.
Your Honor, this now defendant, along with 3 co-defendants, stole a vehicle out of Louisiana and transferred state lines on the same day and was apprehended in Harris County. He's facing a felony charge there due to the fact that they transferred state lines within 24 hours of stealing the vehicle, which was captured on surveillance video. State would be opposed to a bond as state considers him a flight risk.
Any prior criminal history?
No, Your Honor.
Judge, he is from Natchitoches, Louisiana, which is where the offense is from. His family lived there and he was born there. They moved to Manning, Louisiana. I talked to his wife and his girlfriend.
His wife?
mother. That's what I-
23?
That's what I
His
call it.
mother and his girlfriend. Okay. I spoke to his mother, Sophia Smith. She lives in Manning, Louisiana. She will post his bond. And I spoke to Sophia Smith and she'll come over and pick him up. That's, and transport him back to Louisiana.
Here's the thing, Mr. Smith, is I need you to understand that we don't play games. If I set you a bond and you make that bond, we give you 2 weeks to go turn yourself in.
I will, sir. I promise.
We don't play games. So if you fail to do it, I'm going to revoke that bond. I'll set it at 0. I'm going to issue a nationwide warrant for your arrest. I'm going to get you because you can't run forever. And the next time, you will not get another one. Do you understand? Okay. I'm going to set you a bond at $1,500. Here's the other thing. Life is short. Life, when you end up with a bunch of convictions, it doesn't become a fun life. What makes life fun is you get knowledge. When you get knowledge, you buy things because you get money. But you only do that when you go out there, school, learn, get a good job. That's what life is about. I'm not picking up convictions.
So, I'm in college right now too, sir. That's why it's kind of creative. I'm
Really in college?
There's audio arts.
And now with all this, really? Dude, when you hang with boneheads, it doesn't end up well, you know? Get a clue so you don't end up back here. Mr. Smith, I'm going to set your bond at $1,500. Just, Mr. Smith,
Yes, sir.
don't disappoint.